We have a quorum. I call to order the meeting of the Bills Committee on Courts Remote Hearing Bill. Let me first invite representatives of the administration and the Judiciary Administration to come inside the conference room. The Bills Committee has completed the clause-by-clause examination at the last meeting. We have invited members who would like to propose amendments to the bill to submit the draft amendments before 5 p.m. on 10th of February to the Bills Committee. As at that time, the Secretariat has not received any draft amendments from members on the bill. The Judiciary Administration submitted some draft amendments to the Bills Committee. The paper number is CB brackets 2265/2025 brackets 01. I will now ask Mr. Jose Yam, Deputy Judiciary Administrator, Planning and Development of the Judiciary Administration, to brief members on the draft amendments one by one. Please, Mr. Yam. Thank you. I would like to take this opportunity to first thank the chairman, members, and the legal advisor for providing us with valuable feedback. We have carefully reviewed the provisions. As said by the chairman, we have prepared some draft amendments. The details are set out in the paper. In the annex, you can find the specific changes. Let me now talk about the amendments. There are three main categories for the draft amendments. First, as said in paragraph 3, for clause 2, we have made some changes with the definition of legal representative. In view of members' comments, we propose to take out subclause D from the definition of legal representative and subsume it under the definition of participant in the same clause to avoid any misconception that persons who have a right of audience before the court are also legal practitioners. In fact, on 9th of January, we have submitted to the Bills Committee CB brackets 233/2025 brackets 01. We mentioned that we would make this amendment and we had set out our justifications therein. Let me say also, for the meaning of right of audience, it will vary depending on the context. We consider it desirable to spell out the concept in plainer terms. That is, in the remote hearing context, one is entitled to participate in such. So we have the current amendment. The next amendments are set out in paragraphs 4 and 5 on clauses 41 and 42. Right of defendants to be present at the hearing of an application for leave to appeal and an appeal. We understand that in clauses 41 and 42, they will amend Section 83U of the Criminal Procedure Ordinance, Chapter 221, and Section 36 of the Hong Kong Court of Final Appeal Ordinance, Chapter 484. The impression that the changes give is that it would somehow deprive defendants of the right to attend appeal-related hearings, and members have expressed concerns on whether this approach is appropriate. Taking into account members' comments, we propose the following changes. 1. We will keep the existing provisions of Section 83U of Chapter 221 and Section 36 of Chapter 484 intact. 2. we will add a new section 83 RA to chapter 221 and a new subsection 2A under section 33 of chapter 484 to expressly provide the court, when the court considers it appropriate, with the power to dispose of an application for leave to appeal on paper. 3. We will add a new subsection under section 83Y2 of chapter 221, that is the new subsection 2BB, to empower a single judge to give a direction under the aforesaid new section 83 RA, that is the mode on how an application is to be determined, that is how for an application for leave to appeal. Let me say this, section 46.2 of chapter 484 already provides that a single permanent judge can exercise the aforesaid power. Therefore, there is no need to amend chapter 484. Lastly, we will have some transitional arrangements. That is the new subsections 2 and 3 under the new section 83 RA of chapter 221 and the new subsections 2B and 4 under section 33 of chapter 484. We have specified in such draft amendments transitional arrangements that will apply to all applications for leave to appeal that have been listed for hearing at the time when the bill comes into operation. Let me also make clear one thing. The revised provisions are in line with the policy intent underlying clauses 41 and 42 of the bill. We propose to expressly provide under the law an option and flexibility for the court to deal with applications for leave to appeal by paper disposal where appropriate, such that no parties are required to attend the court. That would include defendants as well as the prosecutions. And this flexibility is proposed to be restricted only to applications for leave to appeal as opposed to substantive appeals, because in an application for leave to appeal, the court is concerned with whether the grounds put forth are reasonably arguable and not whether the appeal should be allowed or dismissed. Thus, for cases which clearly show on the written submissions that this threshold is or is not met, the applications can be disposed of by paper without the need for a hearing. The paper disposal option will facilitate the efficient handling of such leave applications and, in turn, the listing of the substantive appeals where leave is granted. We would like to emphasize this. Whether to conduct a hearing, be it in the physical or the remote form, or dispose of the application on paper, it is a case management decision of the court. In making a case management decision, as usual, the court will take into account all the relevant factors and circumstances of individual cases under the principle of upholding the due administration of justice. When it is considered that a hearing should be held, a defendant shall still be entitled to be present at the hearing. On the other hand, if the court decides to dispose of an application on paper and the defendant seeks to attend a hearing, the defendant may still make an application to the court in accordance with the established mechanism. The third category of amendments is textual amendments to make clear certain meaning of the clauses. And before, we have submitted a paper setting out the amendments, the textual amendments that we have set out in paragraph 6. Therefore, I will not go into details. That's it from me. Thank you, Chair. Thank you, Mr. Yam. I will now ask the legal advisor to talk about her views. Thank you. I would like members to note the administration's response in the annex. In the Chinese text, page 31 in the English text, page 35. They are talking about adding section 2A and 2B. In clause 33, on applications that are related, that would cover two types of applications. That is one, leave for appeal in the Court of Final Appeal, and extension for submitting a leave of appeal application. So you can see in 2A, 2B, it would only apply to applications for leave to appeal. And that does not apply to applications to the Court of Final Appeal for extension of time. Before the meeting, the legal advisor, the Bills Committee communicated with the administration. They understand that there is a transitional arrangement in relation to this, and I would urge members to note this. Mr. Yam, any response? Thank you. As the legal advisor said, the transitional arrangement applies only to page 31 in the Chinese text, page 35 in the English text, in clause 42. As you may note in chapter 484, in section 33, there is a section for application for leave to appeal. And it sets out that it has to depend on the circumstances. And such applications would have to be raised within 28 days. And this is the existing section 33, subsection 1. That is, an application to the court for leave to appeal shall be made within 28 days from the date of the decision of the Court of Appeal or the Court of First Instance, as the case may be. So there is no actual appeal decision just yet. They are just talking about the intention to appeal. There is no need to wait for a date to be fixed, which is why the transitional arrangement, that is Section 2A, would only apply to the cases where applications for leave to appeal would take place. Thank you. Any comments from members? If not, I will ask members to raise questions on the administration's response and the draft amendments, if any. 2 members have pressed the request to speak button. Anyone else who would like to speak? If not, I will assign a 4-minute time limit for members who would like to speak. I will give time for the second round of speaking. First, Ms. Maggie Chen.
Thank you, Chair. First of all, I'd like to thank the administration for taking heed of my view, that is to replace the term participants. So I support this amendment. Another point is about the application for leave of appeal. I fully support the present proposed amendment. That is to have Chapter 2 to 183U intact. And I fully agree to that, because in that case, we will not deprive the defendants, particularly the litigants in person, the right to attend appeal-related hearings. And also on page 19 of the document, about the Court of Appeal can have the right to make a decision. And this is has narrowed down to the application for leave. At the beginning, you have to wait for the court to make a decision. But with this amendment, the court could make a decision according to the actual situations. So I think this is very appropriate. We have not deprived the defendant of his right. And in particular, if the appellant is not satisfied, he still has another channel to raise an appeal again. So I fully support these proposed amendments. Thank you, Chair. All right, if there are no further follow-up, the next is Mr. Holden Charles. Thank you, Chair. I'd like to concentrate on the following point. I am thankful that there are proposed amendments to clause 41 and 42, and this is to amend section 83U of chapter 221. Because this would not deprive the defendants of the right to attend appeal-related meetings. Now that we keep the original wording of 83U and also with the proposed amendment, I believe that this kind of misconception could be avoided. I fully agree to that. Another view is that the Court of Final Appeal could make a decision whether there is a hearing, be it physical or remote. It could be conducted with by paper disposal. So I'd like to ask if Mr. Yam could perhaps further clarify this point, especially for the layman. Perhaps Mr. Yam could perhaps further deliberate on this point. Thank you, Mr. Chow, and thank you for giving me a chance to further elaborate on this point. There are two parts. First, let's talk about the Court of Final Appeal. Under Chapter 484, both criminal and civil cases will be conducted differently. For civil proceedings, under Chapter 484, Clause 27D, talking about the application for a leave of appeal. On the third subsection, it is stated that the appeal committee could handle this kind of leave application through paper disposal. However, for criminal cases, there is no such arrangement. So we've made use of this opportunity to propose an amendment that under clauses 41 and 42, we would like to fill the gap here so that the Court of Final Appeal, when handling both civil and criminal cases, could dispose of the case through paper disposal or through a hearing. Right, regarding Court of Appeal, for civil cases, there are existing ordinances to allow the court to handle these cases via paper disposal. This is on Chapter 4, subsection A. It's about under the rules of the High Court. Order 59, 2A, Rule 2A, Section 5, says that the Court of Appeal could rule or make a decision on the application with or without a hearing. So the court could, as it deems appropriate, make a decision. That is for the Court of Appeal for civil cases. Normally speaking, there is also already a mechanism. That is, this kind of application could be handled through paper disposal. And for criminal cases, we have tried to propose an amendment so that it could be handled via paper disposal as well. So this is to make it more consistent. That is, in handling appeal for leave, the court could have another alternative, that is to make use of paper disposal to make a decision. Well, after this round of questioning, we would invite the administration to go through the proposed amendment. But then members could also have the opportunity to raise their questions. All right, next it's myself. First of all, I'd like to thank the administration and the Judiciary Administration to have accepted many of our views, be it actual contents, actual opinions, or our views on the text and the wordings of the bill. Especially on the representative, I welcome your proposed amendment. And also under textual administrations, I'm very glad to see that many of our views have been taken heed of, well, including the definition of remote hearing order, and also about the intent and purpose, and also public access in the English text. Now it is proposed to amend it to open proceeding, to add open proceeding after public access. And for the definition of courtroom, it has been made clearer now. That is under Annex 2. It is stated that the court building with court premises specified in Schedule 2. And also regarding definition of protected session, and it has now made clear that this does not include the adjournment of proceedings. So I really welcome these proposed changes, and I thank you for taking heed of our suggestions and views. Next member, Ms. Yong Ha Yan. Thank you, Chair. I'm also in support of the proposed amendment from the administration, and especially about the term participant. So it doesn't, the right of audience doesn't, it means entitled to participate. And also in paragraph 5, it states that there is a flexibility is proposed, and to allow that there is a kind of written kind of submission. So is it necessary to have this kind of written submission? When does the applicant have to submit this written submission, or is it necessary every time? Is it a threshold that it has to be submitted every time? Thank you, Chair. Mr. Yan? Thank you, Chair. Thank you, Ms. Yong, for your question. We're not talking about two types of courts. First, the Court of Appeal and the High Court and the Court of Final Appeal. So if a party is to submit an application for leave, he has to submit a very detailed written submission with all arguments and reasons stated, and then that will be left for the court to make a decision. On paragraph 5 on the paper, it states that for cases that clearly show on the written submissions that the threshold has or has not been met, then the application could be disposed of by paper without the need for a hearing. So for these cases, if it is very clear that the application for leave, the leave permit could be submitted, then we could enhance our efficiency for the listing of the cases. Whereas for some other applications, there may be very apparent that they are not substantive. Then the court could, through paper disposal, decline this kind of application. I'd like to provide you with some numbers. For the past 3 years, 2023, 23, and 24, both on the High Court and Court of Final Appeal, for those criminal cases, application for leave application, we found that for those that have been listed to the first court date in the High Court, it would take 40 to 50 days, and for Court of Final Appeal, it would be from 30 to 40 days. So we believe that if these applications could be handled via paper disposal, the efficiency could be greatly enhanced. That is, the listing of the substantive appeals could be enhanced. That is, it could be listed more efficiently. So we believe that this is a chance to provide the court with an alternative, with another mechanism, so as to enhance its efficiency. Thank you. Chair, I'd like to follow up on one point. My question is basically on this. From a legal practitioner's point of view, I'd like to ask, if I'm going to make a written submission, should I make it together with my application for leave? That is, telling the court that I believe that this could be done through paper disposal. I don't need a hearing. So that does it mean that I have to submit the written submissions when I am making the leave application? Or should I wait for an instruction from the court asking me to submit this written submission? Mr. Yan?
Thank you, Chair. Thank you, Member, for the questions. In general, for applications for leave to appeal for the written applications, I understand that legal practitioners would already set out the justifications in the application, and these would be in detail. Regarding what the member said about for the Court of Final Appeal, that is application for leave to appeal, the transitional arrangements of which will not apply to extension of time applications. It is because, as I said earlier, 28 days would be offered to the party who would like to appeal to apply for leave to appeal, and if they do not have enough time to prepare, they can apply to the court for extension of time to prepare the submissions. In general, we do know that the written submissions would have already set out the relevant justifications, and thus the judge would be able to make a judgment on written submissions. Chair, if I may, let me clarify something that I said. I'm talking about the written submissions for leave to appeal. They would set out submissions on, well, they would set out justifications on whether they can apply for leave to appeal. and they are basically, the administration is basically referring only to written submissions on whether a threshold is being met, or submissions on whether one should attend the court, whether there should be a hearing. Mr. Yam, yes, we're referring to submissions applying for leave to appeal, and they should have already, legal practitioners should have already set out the relevant justifications in the submissions for the court to decide on whether a threshold has been met, and the appeal hearing may already be scheduled with reference to this. Thank you. Ms. Maggie Chan speaking for the second round. Thank you. I would like to ask about Section 83U, Chapter 221, and Section 36 of Chapter 484. Let me say this. I did support keeping these provisions intact, but let me say this. Whether it is physical or remote hearings, the judge must consider all relevant circumstances and be fair when judging the case. So the practice directions would come in handy. For this bill, in order to implement the provisions, we would need good practice notes to make sure the bill's provisions are properly implemented. So I want to ask, what is the follow-up work plan? What communication is going to take place? Would there be, at some point, the Judiciary Administration would come back to the panel on administration of justice and legal services to report on the implementation? Thank you. Mr. Yam, when we conducted public consultations on the bill, we have included some draft practice directions for reference. We also note members' views. We will make sure to revise the practice directions if necessary. We already have existing guidelines during the pandemic. Back then, we did not have the legal basis. That is, we did not have this bill's provisions, but we still had to hold remote hearings, and the guidelines were promulgated and uploaded onto the judiciary website. So please rest assured, we are not starting from scratch here. Subject to passage of the bill with members' approval, we will promulgate the practice directions as soon as possible. Just like any other practice directions, these are operational details of the judiciary, and we would leave it to the chief judge to make clear rules in the practice directions so that it can be of reference to other judges. Thank you. Any other questions from members? If not, I will ask the Judiciary Administration representative to go through the changes one by one. Should I only read the changes? Sure. First, Clause 2. For definition of legal representative, it would include a legal officer as defined by Section 2 of the Legal Officers Ordinance, Chapter 87B, a solicitor or a barrister as defined by Section 2(1) of the Legal Practitioners Ordinance, Chapter 159, and C, an official prosecutor who is appointed under Section 13 of the Magistrates Ordinance, Chapter 227. After that, it will be deleted. All right, please proceed. Next, the definition of participant. in relation to a proceeding. A means a person who in that proceeding is 1. A party, 2. An authorized representative of a party, 3. A legal representative of a party, 4. A witness other than a vulnerable witness, or 5. An individual who, capital A, is appointed to advise or is involved in advising on any matter in relation to the proceeding. So we have essentially deleted in the lead-in officer or. Capital B is appointed to assist or is involved in assisting the JJO presiding at the proceeding. C is appointed to assist or is involved in otherwise facilitating the conduct of the proceeding. Or capital D, this is newly added, is entitled to participate in that proceeding under an ordinance or a practice direction issued by the court, and small letter b includes any other person who is allowed by the court to be involved in that proceeding. Let me remind members that, let me remind Mr. Yam that we should go through this slowly so that members and the legal advisor can also refer to the English text. If there are no questions from members, let's proceed. Alright, let's go to the definition of remote hearing order. Remote hearing order. It would mean an order made under section 6.1 or 4 and, if applicable, varied under section 7.3 or 8.1. So section 7.3, this reference is new. Alright? Chair, I will now move on to clause 8. Court may vary or revoke remote hearing order. Subclause 1. The court may, on its own motion or on application by any party to a proceeding, vary or revoke a remote hearing order for the proceeding. Now, this following part is added, and may impose any condition that the court considers appropriate. The original subclause 2 is not amended, but I'll read it out loud anyway. An order may only be varied or revoked under subsection 1 if the court, after considering the factors under section 9, is satisfied that, in the circumstances of the case, it is in the interests of justice to vary or revoke the order. We have added a subclause 2A after subclause 2. Subclause 2A. The court must inform the parties to the proceeding of a decision under subsection 1. There are no changes made to subclause 3. Alright, please proceed. Thank you. Now we're on clause 10. Sitting by JJOs. Where a JJO conducts a remote hearing under this ordinance, the JJO is deemed, it says originally for all effects and purposes, now it would say for all intents and purposes, to have satisfied the requirement under any law to be physically present at the proceeding. Members are good with the English text? Alright, please proceed. Clause 15. Attendance at remote hearing deemed to be physical presence. A participant who attends a remote hearing through a remote medium in compliance with a remote hearing order is deemed, like the previous clause that we talked about, we have replaced for all effects and purposes with for all intents and purposes, to have satisfied the requirement under any law or an order or direction of the court to be physically present at the proceeding. The change is the same in the English text. Thank you. Please proceed. Clause 19, transmission of documents. Subclause 1 has no changes, but I'll read it out loud anyway. Subclause 1, a document in relation to a remote hearing may be transmitted electronically as directed by the court. Subclause 2, where a document is transmitted in compliance with a direction under subsection 1, the transmission is deemed for all intents and purposes. It was originally for all effects and purposes to have satisfied the requirement under any law to send such a document for the purposes of a physical hearing. All right. Please continue. Clause 21, signing or writing on documents. There are no changes made to subclause 1, but again, I'll read it out loud anyway. If a participant to a remote hearing is required to sign or write on a document under any law or an order or direction of the court may, for the purpose of the requirement, request that the participant sign or write on a document in a way directed by the court. Subclause 2, where a document is signed or written on in compliance with a request under subsection 1, the signature or writing is deemed for all intents and purposes. Again, it was originally for all effects and purposes to have satisfied the requirement to sign or write on document for the purposes of a physical hearing. Subclause 3 is a definition of right. Again, there are no changes made to this. All right, please proceed. Thank you. Clause 24. Chair, excuse me. I skipped one clause because we should have started with clause 23. There is a change made to the English text. No change has been made to the Chinese text in clause 23. So let me go through clause 23 first.
heading 嚇，我哋係加咗
內容就冇改到。
We have changed the heading, but not the contents of the English text. All right, I accept this amendment. Let me now get to clause 24. Broadcast of an open proceeding. The court may cause, it was originally cause, it is now direct, an open proceeding to be broadcast. Let me say this. This change would make it much clearer, the provision, because the word cause is a bit confusing. Right, in the English text, it's the court may direct an open proceeding to be broadcast. So that is subclause 1. Now let's move on to clause 26. For subclause 5, we have some definitions. Let's first talk about for the definition of protected session. A. In relation to a proceeding that is conducted through a remote medium specified for the proceeding means the proceeding and includes the following periods, and there's a new part added here, on each day of the proceeding. That would include 1. The period before the start of a proceeding when any of the specified persons is already connected to the remote medium. 2. Any breaks during the proceeding as ordered by the court. And 3. The period after the end of the proceeding when any of the specified persons is still connected to the remote medium. And B.
In relation to a proceeding that is conducted in a courtroom means the proceeding and includes the following periods, and these few words are newly added, on each day of the proceeding. And that include 1. The period before the start of the proceeding when any of the specified persons is present in a courtroom. 2. Any breaks during the proceeding as ordered by the court. And 3. The period after the end of the proceeding when any of the specified persons is still present in the courtroom. All right, please move on. Right. Next, definition of courtroom. Courtroom means a place in a court premises specified in Schedule 2. This is newly added, and this replaced the word building, where a proceeding is being conducted regardless of the mode of hearing for the proceeding. All right. Next, clause 41. Clause 41. It's new to add 83 RA. This is a new 83 RA. The title is Determination of an Application for Leave to Amend. 1. The Court of Appeal may direct that an application for leave to appeal be determined with or without a hearing. And 2. Subsection 1 applies to an application for leave to appeal that was made but has not yet been listed for hearing before the relevant date as if it were made after that date. And 3. In this section, relevant date means the day on which the court's remote hearing ordinance, certain number of 2025, comes into operation. And clause 41A, which is also newly added. Section 83Y amended, brackets, powers of Court of Appeal under Part 4, which are exercisable by single judge. After Section 83Y bracket 2 bracket BA, after that we'll add bracket BB to give a direction under Section 83RA. All right, please spend some time going through the English version as well. Any views from the legal advisor? Any further supplement? No. Let's now move on to the new Clause 42. Subdivision 2, Hong Kong Court of Final Appeal Ordinance, Chapter 484. The new Clause 42 reads as follows. Section 33 amended, brackets, application for leave to appeal. Subclause 1, after Section 33, bracket 2, add, bracket 2A. An application under this section may be determined by the court with or without a hearing. Bracket 2B. Subsection 2A applies to an application for leave to appeal that was made but has not yet been listed for a hearing before the relevant date as if it were made after that date. Subclause 2. After Section 33, bracket 3, add bracket 4 in this section. Relevant date means the day on which the court's remote hearing ordinance, bracket, certain number of 2025, comes into operation. All right, please go through the English version as well to see if you have any questions. Any views from the legal advisor? Thank you, Chair. Regarding the transitional arrangements, we have not noticed any questions regarding the legal aspect or the drafting aspect. The administration has replied us regarding clause 41 and 42 on paragraph 15 and 16. We do not have further follow-up questions. Thank you, Chair. All right, thank you. Members, if you have no further questions regarding the proposed amendment made by the Judiciary Administration representative, I would like to ask members if you have any objection or any further views. Well, if not, we hope that the Judiciary Administration will submit a complete and official set of draft amendments to our committee, and these will be conducted via paper distribution. Well, depending on whether members have further views after receiving the document, we will then decide on whether we need to convene an additional meeting. Well, basically up to this point, we would decide on handling this draft amendment by paper distribution. All right. Next, we go through the timetable. After going through the proposed amendment, we will then resume the second reading of the proposed bill. Will Mr. Yan please go through the timetable for us? Thank you, Chair. We have checked with the LegCo Secretariat. We now propose that the resumption of the second reading of the bill will be proposed on the 26th of March of this year. All right. So the proposed resumption of the second reading at this Legislative Council would be the 26th of March, 2025. The date for submitting a verbal report by the Bills Committee to the House Committee would be the 28th of February, 2025. And the deadline for giving notice of amendment to the bill will be on the 17th of March, 2025. So please take note of these dates. And I'd like to ask if members would support or agree that we shall resume the second reading of the bill on 26th of March, on the LegCo meeting on the 26th of March. All right, no objection. If members do not have further views, I declare the meeting adjourned, and I'd like to thank the government representative and also the Judiciary Administration representative for attending the meeting and taking heed of our views. Thank you very much. Meeting adjourned.